Greetings and salutations, my fellow sovereigns. This is the Vocational Science Freedom Saturday night Civics and Sovereignty class, and we will be continuing our reading from a document entitled U.S.A, the Republic that No One Lives in. And we've been reading from this document for a couple nights, and we left off at page 29 under Expatriation. And if you want to grab the documents, they are in the chat on the Gilded server in VSOF class stream, and also they will be in the links for the mega folder, which will be in the show notes for all of the classes, whether they are uploaded onto Odyssey, Rumble, or eventually back onto YouTube, now that we created a new page after being purged off of YouTube because of probably talking about too many things that the communists don't want us to talk about. If you would like to join the Vocational Science Freedom Gilded server and join in the chat rooms and share with all the information that we give out on that server, you can go to any of the links in the show notes on either Odyssey or Rumble. And you can also go to the About section in Odyssey, Rumble, and on YouTube. And the link is gilded.gg/VSOF. And then make sure when you get to the Gilded server, make sure that you hit apply up here in the upper left-hand corner and not just follow. And then that will allow you to join in with everyone. Okay. So let's open up the U.S.A, the Republic that no one lives in. And as we left off, it left off at expatriation, and the document that they were talking about regarding on July 27th, 1868, which was back up on page 21, which was the document that I said I'd bring up the next class, is in the links. And so let's open that up. Well, hold on. Let me read the paragraph here, and then we'll open up the document. Okay, so on July 28th, 1868, one day before the 14th Amendment took effect, an act of Congress was passed. This act was 15 United States statute at large, known as the Expatriation statute. Though this statute is no longer included in the United States Code, it has not been repealed and is still in effect. Now, interesting thing about that is that I did actually find it in the United States Code. But the interesting thing about it is that there is a change of one word, and I'll get to that word and what the change is when I read the document, meaning the act. So this statute is extremely important because it is the public municipal law the individual can use for private purposes to remove herself from the private trust law operating in the public sector, meaning what they created with the 14th Amendment. That is, a private individual who has found himself or herself bound by the private law that is being used in the public sector to promote public policy of compelled performance, which he did not have a choice in, can access the public positive statute law to move back under the liberty and protection of the Republic and its separation of powers. So, to take a look at the Expatriation Act, which is in the links in the Gilded server. So it's 15 Statute 223, 224, and this was the session of Congress 1859, 1869, 14th Congress, so on and so session. An act concerning the rights of American citizens, notice that, American citizens, in foreign capital S states, July 28th, 1868. Rights of American citizens in foreign states, rights of expatriation declared, protection to naturalized citizens in foreign states, release of citizens imprisoned by foreign governments to be demanded, facts to be communicated to Congress. Whereas the right of expatriation is a natural and inherent right of all people, indispensable to the enjoyment of the rights of life, liberty, and the pursuit of happiness, and whereas in the recognition of this principle, this government has freely received immigrants from all nations and invested them with the rights of citizenship. Notice that, invested. So when you come from someplace else, you get invested with the rights of citizenship. If you're born here in one of the republics, it's automatic, meaning you're one of the people. And whereas it is claimed that such American citizens with their descendants, meaning their heirs, are subject to foreign states owing allegiance to the government thereof, and whereas it is necessary to the maintenance of public peace that this claim of foreign allegiance be promptly and finally disavowed. Therefore, okay, so foreign allegiance. What is the foreign allegiance that they're talking about? Well, the foreign allegiance that they haven't quite created yet because the 14th Amendment came right after this. So the attorney gave themselves a way out, which is this document, and anybody else that wanted a way out. Because if they didn't give you a way out, it would technically be forced slavery, to be subject to the jurisdiction of, which is how the 14th Amendment is written. So in order to be a citizen of the United States under the 14th Amendment, you have to be born or naturalized in the United States and subject to the jurisdiction thereof. And that's important because if you're born or naturalized but not subject, are you a citizen of the United States? The answer is no. But they do all this by presumption. But I'll get to that in a minute. All right, to continue. Therefore, be it enacted by the Senate, House of Representatives of the United States of America and Congress assembled, that any declaration, instruction, opinion, order, or decision of any officers of this government, which, and by the way, the aspect of this government, this is part of and parcel of the change of the wording, right? When he was talking about in here about notice the Expatriation Act, though this statute is no longer included in the United States Code, well, where it is included in the United States Code, which is it's now back there. Now, maybe at this time when he wrote this, maybe they hadn't put it back. I'm not sure, but I did find it. But the difference is that the wording between the one that's in the United States Code and the original is that the one that's in the United States Code states not this government, but it states of the Republic. We're right here particularly. So let me read this right here again. Okay. So be enacted so-and-so, any declaration, okay, any officers of this government which denies, restricts, impairs, or questions the right of expatriation is hereby declared inconsistent with the fundamental principles of this government. In the United States Code, the one they have in there right now, it doesn't say this government. It says the Republic. Now, why would that be? Well, it's because when this was enacted, it was the aspect of the government of the Republic doing it. But the United States Code right now could not call themselves this government because they wouldn't have any authority to do this because it's the United States federal corporation. So they had to put the Republic here instead of this government. And it's a very interesting thing to go and read because of that reason. It's almost absolute. Well, it's not almost. It is absolute proof of the fact that the United States Federal Corporation, what they're doing is not the Republic. Okay. So, all right, to continue. Section 2. And be it further enacted that all naturalized citizens of the United States, while in foreign states, shall be entitled to and shall receive from this government the same protections of persons and property that is in accordance with to native-born citizens in situations and circumstances. Number 3, and be it further enacted that whenever it shall be made known to the President that any citizen of the United States has been unjustly deprived of his liberty by or under the authority of any foreign government, it shall be the duty of the President forthwith to demand of that government the reasons for such imprisonment, and if it appears to be wrongful and in violation of the rights of American citizenship, notice that. 2 different citizenships here. Citizen of the United States, American citizenship. These are 2 separate, different things. That the President shall forthwith demand the release of such citizen, and if the release so demanded is unreasonably delayed or refused, it shall be the duty of the President to use such means, not amounting to acts of war, as he may think necessary and proper to obtain or effectuate such release. And all the facts and proceedings relative thereto shall as soon as practicable be communicated by the President to Congress. Approved July 28th, 1868. And that the 14th Amendment to the United States Constitution was allegedly adopted on July 9th of 1868. Well, guess what? It was never properly ratified, the 14th Amendment, and there is congressional record as late as, I think, in the 1960s, where on the floor of the Congress, they specifically argued the fact that the 14th Amendment was never properly ratified, which I don't have up right now, but it is in the mega files for the VSOF online library that you guys can go look at. Just look under 14th Amendment and it's in there. Okay, so just to understand this, so the attorney had to give everybody a way out or else they were going to be locked in the 14th Amendment and be subject to the jurisdiction thereof, okay? And make notice again that there's 2 separate citizenships here. One citizen of the United States and one American citizenship, right? Okay. So that's what they're talking about in this document. The U.S.A., the Republic, is the house that no one lives in. So that's what they're talking about. And just another note, just to remind everyone, the little hyperlinks here, if you want to go see what they are, you can hold down Control and then right click, and it'll take you to the document or the hyperlink of whatever they're talking about. And since their webpage is still up, you can go do that and take a look at it right here. So that's what they were doing. They had to give a way out. So that's your way out of this private trust law of the 14th Amendment, is the Expatriation Act. And in the Vocational Science of Freedom Status Doc set, we make that clear in one of the documents, which we call the Declaration of Nationality. So in the Declaration of Nationality, you expatriate and then repatriate back into your own house and also back into the de jure republic of wherever you were born, whether it be Wisconsin, Texas, whatever. You state clearly that you renounce, disavow any connection, or that you are a citizen of the United States, and that you repatriate into being a de jure state citizen of one of the several states of the Union. Okay. So to continue. All right. So the preamble of the 15th United States Statute at Large is unique in that Congress laid the legal discussions to rest before the statute took effect to assure it would not be tampered with legally in any way. It stands as written, and there is therefore the citizens to use as public law for the private purpose of moving themselves from one political or territorial jurisdiction to another. Because that's what the presumption is that everybody's in some sort of federal territory. And if you start looking up state statutes, there's a very specific term of art that they use, and it's called "in this state." But then when you go and you look up what the definition of "in this state" means in state statutes, it actually means the District of Columbia, right? So the presumption is that you are a citizen of the United States and that you are a resident of D.C., and that's an aspect of this territorial jurisdiction that they're talking about. So to continue, this means there is a way out at any time of the United States government policy or law, including those of its political subdivisions, that is based on private law. Whenever you find yourself bound to any compelled performance you had no choice in, you are operating in the jurisdiction of the United States government and its political subdivisions, where there is no republican form of government and its separation of powers. By applying public laws for your private benefit, you can break that dictatorial jurisdiction anytime you choose. And that's the difference between public law and public policy, because all the aspects of public policy is what they write in the statutes, acts, ordinances, and codes to administer the estates of infants who've been abandoned. It's all the aspect of probate of what they're doing. So the insidiousness of the 14th Amendment is that even though it is private contract law of the trust, it is not a bilateral contract where both parties sign the document after a meeting of the minds. The 14th Amendment is a quasi-contractual. That is, it is not a true contract as recognized in the general common law. Rather, it is an adhesion or unilateral contract where only one party binds himself. Another way that this happens is also a pledge. A pledge is another aspect where only one party need make an action and then bind themselves to it. In this case, a person agrees to the private trust law merely by his silence. If a person does not speak up to let his choice be known, the trust will assume he or she is a part of and beneficiary of it. They will assume you have gifted your life to the trust for the benefit they have to offer, which is things like going to jail, using monopoly money called Federal Reserve notes, and so on and so forth. And here's the aspect. This is the part of beneficiary that's important to understand. If you ever take a benefit from your own estate, instead of coming forward and claiming the entire gross estate as the heir and properly administering it as the sole lawfully appointed executor on public record, if you take a benefit from your own estate, there's a term in law for that. It's called beneficium abstinente. It's Latin. And what it means is that if you take a benefit from your own estate, you are abstaining from being the heir. Now, usually when this would happen back in Roman civil law was that if the estate had some exorbitant amount of debts attached to it that actually amounted to more than the estate was worth. That was the idea, that you could, the aspect of beneficium abstinente, say, nah, I don't want all that debt. Thank you very much. No, thank you. But if you're doing it here in the Republic, and the aspect of taking a benefit from them, because everything that they're doing is based on the productive value of our estates. That's where all the credit comes from in this dual bookkeeping entry system, right? It all comes from the credit of our estates. Well, if you're saying I'm going to take a benefit from my own estate instead of claiming to be the heir and properly taking care of it as the sole lawful executor, well, then you're asking for a snippet of what could be the totality of what is actually lawfully yours. And so therefore that will then create this adhesion contract and the presumption, because it says they will assume that you have gifted your life to the trust for the benefit they have to offer. That's exactly the point. And to make another point, if you really want to fully understand how all of this works, I highly suggest that everybody go and watch the New World Order Agenda, Edward Mandell House, The Man Who Stole the Republic, which is the first main class up on top of the Vocational Science of Freedom on the Odyssey page. So it's odyssey.com/@VSOF:8. And in this class, I completely break down what they're doing as far as giving us benefits and privileges, and that they are keeping from us the rightful claim of being the heir and having redemption of our estates. So I highly suggest that everybody go watch this to get a better understanding of what they're talking about in this document, and specifically right here in this particular paragraph. Okay. All right. So to continue, under the 14th Amendment, the citizen who does not make his choice known for or against the trust relationship is assumed to be a beneficiary, because he or she has not stated otherwise. As a beneficiary, you are an outlaw as far as the Constitution is concerned. You are operating outside of the Constitution. While operating outside the Constitution, you only have relative right under the Bill of Rights and the Constitution, because private contract law takes priority over constitutional law. Now, a lot of people say, well, how is that possible? Well, it's because it's written in every single constitution, both state and federal. They all have a clause that clearly states that there shall be no law passed abrogating the right of contract. So in every constitution itself, it tells you that contract law is higher than the protections that you would have had under the Constitution had you not contracted them away. So that's how that works. So just be aware of that. Okay, next section, public policy and the democracy. As long as you are under private trust law operating as public policy, you are under the conscience of the few who influence and make the public policy of the trust for the benefit of its members. These groups are known as special interest or political action groups. This is why the news reports almost daily that some poll has been done to see how the people feel. Under the 14th Amendment public trust, majority rules. Right. This is why you hear the word democracy all the time. See, that whole system is the democracy. You, us, we the people, live in a republic, not a democracy. Two different things. It refers to the 14th Amendment public trust that everyone is a part of because of their silence. It tells you that mob rule and communalism are the order of the day. It tells you that if a special interest group can create enough waves of influence, the trust will be compelled by popular demand to accept the new policy the special interest group has been promoting. If you are part of the democratic trust, you have to go along if you do not know your options. Private law is conscience, ecclesiastical, and religious law, which I've gone over many, many times. And if you guys do not know or haven't quite learned the differences in the various different forms of law, the other class I suggest that you watch is under the playlists on Odyssey, go to the Totality of Law class. The Totality of Law class will explain to you all the different forms of law, if indeed you do not yet know them, or this paragraph was a little bit confusing to you. Okay, so these different laws, they are equal to each other under the 14th Amendment trust. There is no true religious liberty because the individual is part of the conscience of the trust and the few that make the rules called codes. In fact, there are no true freedoms at all as listed under the Bills of Rights. Try publicly saying much against the IRS and their prima donna attitude to see how absolute your liberty of speech is. As alluded to earlier, the free citizen of the soil of each state in this union is not affected by the private law of another individual or group trust unless they choose to bind themselves by silence. Silence is slavery under Roman civil law principles. Unless one stands to claim his sovereign rights, he does not have any. And there's a maxim also that goes along with that. There's a maxim of law that states, he who slumbers on his rights has none. Makes sense? If you do not make your will known, you don't have one. Which is why all the vocational science freedom status docs are a continuation of your will, so that there can't be any presumption that you don't have a will, right? To continue. Each person must exercise a choice to be free or enslaved. The public municipal law will uphold your right of choice, but you must make a choice the law can uphold, meaning make your will known. Yes, if you're a beneficiary of the trust, you are living under an administrative democracy, parliamentary democracy, a communal association, where there is no separation of powers and your rights are subject to the will of the majority. You have no absolute rights, only relative rights. The codes and revised statutes are for the general good of the association. Few citizens of the United States realize the republic for which it stands is a house which no one is living in. So understand that. If you're not taking up your claim and saying, this is who I am, and this is the side of the fence that I'm on, you are going to be stuck under the statutes, acts, ordinances, and codes. And what are some of those statutes, acts, ordinances, and codes? Civil rights laws. Because civil rights laws are laws that are granted by government. Now, a unalienable right is a right which you have by nature and nature's God, as which was laid down in the Declaration of Independence. Two different kinds of rights here, because you're in two different kinds of status. All right, to continue. With or without the check of a dictator, power has been passing from the legislature to the civil service or bureaucracy, which alone feels competent to manage the complex and technical business of the state. Anglo-Saxon countries are taking a place alongside of the countries of continental Europe with a body of administrative law and its administrative courts, at least in embryo. The popular conception of liberalism is undergoing a great change. Liberty lingers on as a name, but a name used to designate almost the opposite of 19th century liberalism, because the definition of the word liberty, or the root word, which is liber. Liber is book. It's where you get the word library from. And if you actually had a liberal education, you would know the trivium and the quadrivium. And the trivium is grammar, logic, and rhetoric, and the quadrivium is mathematics and geometry, which is mathematics and space, music, which is mathematics and time, and astronomy, which is mathematics and space and time. If you had a liberal education, you would study what those are, because those are called the 7 liberal arts. But in the Prussian education system, you're not going to find them. And if you do find them, like maybe mathematics, they're woefully done incorrectly. Let's just put it that way. A good example is Common Core math, but I don't want to digress here too far. But you get the point, right? Okay, so liberty lingers on. Okay, 1904. The new liberty consists mainly in legislative restrictions which keep one man from exploiting another while the state exploits both. Right. Administrative courts. Remember, all these courts out here are private for-profit courts, and they all have separate purses from the state. That's why you can sue them, because they don't have 11th Amendment immunity. So just remember that as well. Okay, now take a look at how your own federal government defines the difference between a republic and democracy. The following was taken from U.S. Government Training Manual number 2000-25, dated War Department, Washington, November 30th, 1928, and prepared under direction of the Chief of Staff. Under which do you live? ? Democracy or republic? Democracy. a government of the masses, authority derived through mass meeting or any other form of direct expression, results in mobocracy. Attitude toward property is communistic, negating property rights. Attitude towards law is that the will of the majority shall regulate, whether it be based upon deliberation or governed by passion, prejudice, and impulse, without restraint or regard to consequences. Results in demagogism. I don't know if I'm pronouncing that correct. License, agitation, discontent, anarchy. Republic. Authority is derived through the election by the people of its public officials, best fitted to represent them. Attitude toward property is respect for laws and individual rights, and a sensible economic procedure. Attitude toward law is the administration of justice in accord with fixed principles and established evidence, with a strict regard to consequences. A greater number of citizens and extent of territory may be brought within its compass. Avoids the dangerous extreme of either tyranny or mobocracy. Results in statesmanship, liberty, reason, justice, contentment, and progress. It is the quote-unquote standard form of government throughout the world. A republic is a form of government under a constitution which provides for the election of an executive and a legislative body who, working together in a representative capacity, have all the power of appointment, all power of legislation, all power to raise revenue, and appropriate expenditures, and are required to create a judiciary to pass upon the justice and legality of their governmental acts, and to recognize certain inherent individual rights. And this is where you get the separation of powers. There's no separation of powers in a democracy. Only in a republic do you have the separation of powers. And I might add here one more thing that's not obviously in this document, and that's the grand jury. Because the grand jury is the fourth branch of government, which is above all the rest of these. Because if any of these go sideways, the grand jury steps in and says, no, you're not doing what we told you to do, and we'll take you out of office. Okay? So take away any one or more of the four elements, and you're drifting into autocracy. Add one more to those four elements, and you are drifting into democracy. Autocracy declares the divine right of kings. Its authority cannot be questioned. Its powers are arbitrary or unjustly administered. Democracy is the quote-unquote direct rule of the people and has been repeatedly tried without success. Our constitutional fathers, familiar with the strength and weakness of both autocracy and democracy, with fixed principles definitely in mind, defined a representative republican form of government. They, quote, made a very marked distinction between a republic and a democracy and said repeatedly and emphatically that they had founded a republic, close quote. A French diplomat, politician, and statesman by the name of Alexander de, I believe that's Tocqueville, made the following observation about the democracy of the United States when he visited here in the early part of the 1800s. The tyranny of public opinion, de Tocqueville argued, could prove more burdensome than the tyranny of any monarch. Democracy, communalism, does not guarantee efficient government. It does provide freedom for the pursuit of one's own interest, subject always to the tyranny that comes from the majority insisting that its values, religious conscience, and ideas should be safeguarded. Tocqueville saw that the new state power as rather that of the parent, except that the parent prepared the child for manhood. The democratic state was interested in perpetuating childhood in man, and that's the point. Why does it seem like every single thing that happens anywhere, whether it be in medicine, whether it be in law, whether it be in schooling, all seem to basically want to perpetuate childhood from cradle to grave? Well, there you go. That's the reason. It would provide for his necessities, facilitate his pleasures, and direct his industry. What remains, Tocqueville asked, quote, but to spare them all the care of thinking and all the trouble of living. And there's a little link here, which I'll go check out. Number 59 says, okay, so this is from, must be his book, Democracy, from Democracy of the History of Ideas, Volume 1, 1973. Okay, so I'm pretty sure Tocqueville lived before that, so that might just be a quote from that book, quoting him again. So, okay, so losing the law. Between 1868 and 1933, the 14th Amendment had little effect upon the general population. This was because the people still controlled the substance of their law, right? Which means common law courts of record that rendered general verdicts from juries. Because when a court of record that has a jury renders a general verdict, the jury decides both the facts and the law. They can nullify the law, which is what jury nullification is all about. That's what we should be doing and what our system was set up to operate as. But under this filth, they get rid of all that. In fact, I've actually seen cases where the judge didn't go along with what the jury said. Why? Because they don't matter. Because there are 12 persons, meaning infants, that are sitting in a sandbox throwing cat shit at each other. Doesn't matter. So understand that the substance of their law, meaning what I just explained, was eventually rolled out. And then that's where you get the aspect where they're trying to merge law and equity during this time, around after 1933, that they tried to merge law and equity. Well, that's like trying to merge water and oil. Doesn't work. You have to keep shaking the shit out of everything in order for it to stay there. Well, I say we pull it back out to where it should be, take our power back, and say, no, we don't want to have anything to do with that. You can keep your filthy democracy, and you can keep all your filthy administrative courts, and we'll be over here on the common law side with 100% full liability, both to you and me, right? That's what we should be doing. But to continue, that is, the only people affected by the 14th Amendment relation during this time were those that held licenses and contracts with the government of the United States or were in its employment. Right. Go look up the definition of federal personnel in the United States Code. It'll show you that someone who is federal personnel has a deferred retirement program from the United States. You know what you call that? Social Security. So everybody that's got a Social Security account has a deferred retirement program from the United States, and that you are then considered by that definition to be federal personnel, which is what they're talking about here. We're in its employment, right? It was not until June 5th, 1933 that the 14th Amendment took a whole new power. On that date, HJR, House Joint Resolution 192, was passed, and the American people voluntarily gave up their law because they voluntarily gave up their gold. Well, I wouldn't necessarily call it voluntary when somebody's threatening you with fine or imprisonment, which is what they posted on every single post office about turning in your gold or else. Well, that's a threat. Well, okay. That's not exactly voluntary, but anyway. So that is correct. The people voluntarily gave up their law. Well, again, I'd say they were forced to do so. But to read the history just after that time and talk to people who lived through it, they will tell about the government agents who came around to confiscate the gold that was in possession of the people. It appeared from what took place that the people were forced to give up their gold. Yeah, again, forced. However, that is not what could have happened. Going along with the public policy of HJR 192 was actually a voluntary act and is mutable by will. Thus, the individual was a victim of his own ignorance about the law. By accepting the offer of the private credit, meaning Federal Reserve notes, the population was automatically bound over to the private trust, now having gone public because the whole population was moved wholesale into the trust by their silent or negative acceptance. When 51% of the population volunteered for the private trust, it became a public trust. So, yeah, the point is you need to get out of it because you have the capacity to get out of it and never have to deal with this again. And you can do that by getting your vocational science freedom status doc set done and then filing it. And then putting on notice, particularly the Secretary of State of the United States, that you have expatriated. To continue, to understand issues that preceded the 1933 event, we must go back to 1834 when the U.S. Supreme Court declared in Wheaton versus Peters that there was no federal common law. Right. I would argue that there was never any federal common law. Because the trust, the original trust, the United States of America, didn't have any aspects of common law in it. All the common law decisions were settled in the courts. The only thing that the feds had control over were basically 4 criminal matters, which were piracy, treason, the law of nations, and counterfeiting. That's it. Only 4 things. So all of Title 18 is not, and never has been, properly enacted into positive law, because it would be unconstitutional if they did that. So everybody's just going along with the democracy, just floating along in it, just getting fined and feed for their use of their own property, right? So to continue. In other words, the federal government was not set up under the common law as a state in the Union, such as Pennsylvania, Virginia, New York, etc. These states were based upon the substance of the common law and its allodial land titles. Exactly. Allodial means there are no overlords over the land, therefore man is his own king upon the land. The gold and silver that came from the allodial land were public money used for private trade between the citizens of the states. This meant there were no third parties involved in the trading contracts because there was no private enterprise trust, meaning the 14th Amendment, dictating public policy. Trade among the states at the time involved 2-party contracts called free enterprise. The commercial trade taking place between the states was mostly in its infant stages and was regulated by common law. Yet the common law of each colony was foreign to the other colonies without any standard of trade. Most of the political commercial trade was involved. International trade, which was regulated under maritime admiralty outside the Constitution, mandates. And yes, the federal Constitution states that they have control of interstate commerce between the states, which is one of the clauses of the Constitution, which has run everyone over. Because if you're an infant and the presumption is that you're a resident of D.C., well, everything that you're doing bounding around in the states can be considered commerce. That's why everything's considered a commerce crime. And if you don't believe me on that one, you can go look that up in U.S. Code and in the Code of Federal Regulations, CFR. Okay, to continue. With the growth of commerce between the states, there became a need to try and standardize some form of commercial law. Each state had its own laws of commerce as based on the common law, and this created great problems when it came to which state's laws were to be enforced when disputes arose. A federal circuit court judge by the name of Joseph Story was a pioneer in trying to form some sort of standard in commercial law that would appeal not only to the federal courts but also to the state courts. When Story was appointed to the Supreme Court of the United States, he became the principal advocate in the landmark decision of Swift versus Tyson, establishing a general federal civil commercial common law as to create uniformity in commercial disputes involving negotiable instruments in federal and state courts. The decision was based in part on the fact that gold and silver coin, as the substance of the common law, were being transported between states in commerce. Yeah. Not exactly, buddy. Right? Because they're saying now, well, if you transport gold and silver across state lines, that's interstate commerce. Uh-huh. Right. As a result of the substance of the common law being used in commerce, a jury trial was possible in the federal circuit courts. The court proceedings were strictly operated under the authority of Article 3, Section 2 of the Constitution. Justice Story had been aware of Robert Owen's communal concepts in 1833 and the influence it could have on the loss of gold as a fixed standard in trade. Owen was instrumental in promoting ideas of how to move private communal commerce into the public sector. To accomplish this, the law would have to be changed in order to obtain the maximum financial stimulus for commercial growth. For a man like Story, who knew the relationship of gold to the law, he could read the handwriting on the wall. So the undercurrent of corporate special interest scheming that started in 1833, Story knew that somewhere down the road, the American people would lose their law. He knew this would eventually allow private law merchant, meaning the law merchant, to be moved into the public sector, controlling public policy, resulting in the loss of general commercial common law for those involved. In other words, separation of powers would be lost in a favor of the private commercial corporate business to the detriment of the average citizen. Right, which is what you have now. You have United States Incorporated running everything. Also in 1842, Swift versus Tyson decision, Justice Story would assure a trial by jury in a civil cause between states, even if there was no gold standard in the future. What does a jury have to do with fixed gold standard? ? Gold was the land because it not only came from the land, but it was also transportable real estate, portable allodium. The ancient common law was based on real property boundaries or soil that belonged to a person and anything that came from that ground or soil, such as gold or any other precious mineral or rock, was concerned substance in the soil of the common law. I'm going to hit this hyperlink because I'm rather curious as to what 67 says. Okay, so common law is referred to here had to do with the body of the principles and rules and actions relating to the government security of the persons and property, which derive their authority solely from usage and customs of immemorial antiquity, or from the judgments and decrees of the courts, recognizing, affirming, and enforcing such usages and customs, and in this case, particularly the ancient unwritten law of England, 15a, Corpus Juris Secundum. Okay. Well, that's just defining the common law, though. Let me go back and reread this, make sure I'm okay. Because I'm not exactly showing he's making the right argument here with that reference. So, transportable allodium, soil, property, anything, gold standard, mineral was considered soil and common law. I don't know if I could make that connection. But, so anyway, the part of this part, 15a, Corpus Juris Secundum. The common law is referenced here had to do with those bodies and principles ruling action related to the government security, which derive their authority solely from usages and customs of immemorial antiquity. That's the point. That it goes back to before written law, if you will, meaning spoken law, because spoken law is always higher than written law. It says, or from the judgments and decrees of the courts recognizing, affirming, and enforcing such immemorial customs from antiquity. And this, in a sense, particularly the ancient unwritten law of England, right, which is just what I said, the spoken law. So I wouldn't exactly agree with how he made the argument there, but okay, so be it. I just wanted to check it. Okay. So gold in the hands of the common person meant the public law merchant was supreme. Well, I would say that gold in the hands of the common person meant that they're not a bankrupt, because that's kind of the problem. They're running everything through bankruptcy, right? Because the United States Federal Corporation is bankrupt, which we all know. And we're all sitting here playing around with monopoly money in a bankrupt system. Well, if you actually hold gold and silver, you're not a bankrupt. The presumption can't be that you're a bankrupt. And that you need to have benefits and privileges is basically a pauper from the trust, if you will, right? So that's how I would look at that. Okay. All right. So gold in the hands of the common person, public laws. All right. Law merchant was supreme because the person controlled the gold or land where the goods were purchased. In the true historic sense of the common law, the only person who counted was the landowner. Right. Because you have to be a landowner to be an elector, by the way, instead of a votor that is part of a constituary, and that you become a constituent. And you might want to go look up the word constituent, because it's not what you think it is. But anyway, to continue. That is, you could be equivalent to a slave if you did not own land. Also, at the beginning of our country, one could not vote unless they owned land. Well, funny, you just said that after I said it. In a jury trial, the jury had to be made up of the peers of the person on trial. The only true peer of a non-commercial individual, landowner, under the common law was another landowner. Yes, in a sense, that's true. Because, again, they held a allodial title. And it's all about the title, really. It's about holding title. If you don't hold title, well, then you don't own the thing. Land ownership being based on absolute rights with allodial titles, no outside private equitable interest or overseer involved. Right. No property taxes. Historically, the common traders and merchants were nomads. Right. That's the definition of a resident. They were not landowners, nor were they producers. What they made money on was trading in the commodities the land owners produced. In other words, they were the original broker middlemen. When the fixed gold standard was removed, it meant that everyone had been shifted from the civil commerce public law merchant side of the law to the political commerce, private law merchant side of the law, where once you were considered to control the land and the law absolutely, now you are considered to be a non-producing trader, again, resident, with only relative equitable rights, land or no land. The result is that there is no more possibility of a trial to judge the public municipal law. Rather, the trial will be based on the facts of the private implied contract you were now assumed to be involved in. You are assumed to be guilty before proven innocent. Right. That's why when you go to trial for anything, they always say, how do you plead? Guilty or not guilty? Well, what the hell happened to innocent? Can't you plead innocence? That's what you should be saying. Say, objection, Your Honor. I'm innocent. I do not plead to courts of contract. That usually fucks up a Roman civil law court pretty bad. Because you're innocent. You're not a merchant. You're not a resident. You're lawfully domiciled. You're one of the people. And you've come of full age. And you're the sole lawful executor and heir of all of the res, which the administrative court is attempting to administer through a constructive trust, which all came from your estate. So if you claim the estate first, which is the point, because there always has to be an estate before there can be a trust. If you claim the estate, all the trusts go bye-bye. So, to continue, it is the Roman civil law that makes you guilty by accusation, requiring you to prove your innocence. Exactly. Roman civil law is the opposite. Roman civil law is you're guilty until you prove yourself innocent, and common law is you're innocent until proven guilty. But again, the point is you're innocent. You don't have to plead to a court of contract saying you're guilty or not guilty. Swift versus Tyson has been in effect since 1842. However, the Erie Railroad versus Tompkins decision of 1938 stated that there was no longer, quote, general federal common law. The Erie Railroad case was based on the fact that it was assumed that all citizens in the United States had been included in contractual commerce of the private law merchant through the 14th Amendment and H.J.R. 192 outside the Constitution as allowed in Article 1, Section 8, Clause 17. The Erie Railroad decision came 5 years after H.J.R. 192, the removal of the fixed gold standard. This allowed enough time to pass so when the people realized that they had no right to a real jury trial, they would not panic. Erie Railroad was based on H.J.R. 192 because the fixed standard, the law or the gold, of money was removed. It is now up to the individual which commerce he wants to be part of, for it is a political choice. Do you want to be part of the political commerce under the private law merchant of the 14th Amendment, sustained by Erie Railroad versus Tompkins? Or do you want to have absolute liberty and all the absolute freedoms of civil commerce under the public law merchant as supported by Swift versus Tyson? Remember, the courts will not question your political choice, but they must uphold it. However, unless you make the proper action, your choice will be assumed to be with the private law merchant, meaning the 14th Amendment public trust. With H.R. 192, the substance of your law, gold was turned into commodities. That is, the fixed gold standard at $35 per troy ounce of weight and fitness of your money was removed. Once the money no longer had a fixed standard, it could then fluctuate according to supply and demand, just like a commodity, i.e. a bushel of grain. This had the same effect on real property as well. This is called inflation, which is a hidden tax on everybody. Money is the only thing in the United States that has no fixed standard. Right, gold and silver. And I could get into the goldsmith's tale, but if you really want to learn everything about banking and what they're really doing, again, you can go to the Vocational Science Freedom Odyssey page, and you can go watch the entire VSOF banking timeline, or you also, if you want, in the VSOF Odyssey page, there's also, I reposted the documentary called Money is Debt. I believe it's under self-governance. I want to go look for it, but it should be in there. Money is Debt is a really good documentary to go watch in case you want to learn the history of banking and how all this came about and learn more about what banking is. So more of this makes sense to you because it's all explained in there. Okay. Private money. You can still function in contract within the money system of the Republic using the private money because Congress suspended the quote-unquote payment of debt in law by suspending the fixed gold standard. Even though one is outside the 14th Amendment trust and not part or beneficiary of the public policy of the trust, you cannot, quote-unquote, pay your debts in law. Meaning they're not going to take gold and silver, right? All you can do is discharge your debt in equity, which is giving somebody a Federal Reserve note. Because what is the definition of a note? It's a debt obligation. And if you pull out any note in your wallet right now and look at it, you'll find that it's signed twice. Well, why is that? Well, it's because this joker is promising to pay this joker a certain amount of debt. And the Federal Reserve note is just evidence of the debt. It doesn't mean anything. It has no intrinsic value, which was clearly laid down and decided in the Jerome Daly case, also known as the Credit River decision, which stated that, guess what? Federal Reserve notes don't have any lawful consideration. So therefore, they violate every aspect of contract that you would ever use them in for exchange because they don't have any lawful value. There's no consideration. And without consideration, you can't fulfill a lawful contract. So therefore, you can't pay any of your debts. You can only discharge your garbage and equity. So because of this, you are the only one who can determine your worth and value in money and otherwise when not under the 14th Amendment. Please note the explanation of the money system in this section is for educational purposes only. It is never to be used in any legal arguments because the choice of your money, public or private, is a political question, which the courts do not have jurisdiction to decide. Well, unless you actually want to go read the Credit River decision, because it was pretty much decided there. So, when the fixed gold standard was suspended in 1933 by H.J.R. 192, it was not an abolishment of the standard or the law associated with it. It was just suspended. Yeah, kind of like how Nixon suspended it when he suspended the gold standard as well, right? But it's suspension in perpetuity. Right? It's never not suspended, like it never goes back to being what it should be. That is, it was set aside in favor of another law. It was a political decision based on the fact that the people did not rise up and tell Congress that they cannot take away our law or gold, meaning money. Therefore, the Treasury agents came and confiscated the gold, being the law, because the people did not choose to keep the law. The individual could have stopped that from happening, but he would have had to have made his legal and political declaration to not be involved with public law for private purposes, democracy, under the 14th Amendment. Because the people were ignorant of what was taking place by operation of the law under the 14th Amendment, no one knew how to expatriate back into the republic law that was still there. Probably because nobody realized that where they should have gone back to was going all the way back to the Expatriation Act and said, nope, this is the law that I'm standing on to say I want out of here. The Constitution of the United States of America uses the term the several states. This means the territorial government and its Article 1 ecclesiastical or legislative courts under Article 4, Section 4 of the Constitution use the term states in this union. States in this union is different from the several states as used in Article 1 of the Constitution. Article 4, Section 4 of the Constitution guarantees the Republican form of government. States in this union is referring to public municipal law of the Republican states for private purposes, while the several states refers to private law for the making of public policy, i.e. trust law, including the Uniform Commercial Code. Right, because that's the aspect of being able to control corporations as well, right? So two different things. Public policy and public law are two different things. Before 1933, you did not have to call on the Republican form of government and Article 3, Section 2 courts of judicial power because it was automatically there because the gold was there. After 1933, you have to call on the public municipal law for private purposes to have the Republican form of government because the fixed gold standard is not there. Well, what you actually have to do is file your documents in a proper court of record and state that it's a court of record and state what you're doing, that it proceeds according to the common law, that you demand a jury, and then that jury will render a general verdict in accordance with common law. That's what you need to do. Gold coin today is commodity gold, also called fiat money. And that is why it fluctuates in value on the commodity markets daily. It is not guaranteed by the U.S. Treasury as to its weight, fitness, or fixed standard. As to the 16th Amendment, it has not applied since 1933. Today, the 16th Amendment pertains only to the federated states as political subdivisions of the District of Columbia, right, which gets into the Buck Act and all the aspects of the zip codes and all that shit, as well as American Samoa, Guam, Puerto Rico, etc., are not construed as quote-unquote capital S states of the United States, not to be confused with the 50 lowercase s states of the Union. Remember that you are presumed to be a 14th Amendment citizen since 1933 unless you bring forth evidence to prove your political choice is otherwise. Right, your Declaration of Nationality from the Vocational Science Freedom Status Doc set. It is all part of your express will, right? Because again, the status docs are a continuation of what? Your will, because you don't have one, because everything's been probated. Silence on your part means that you have conveyed your property to the public trust and want to be treated as a constructive trustee outside the Constitution, which is what they're doing to you every time you walk into a private for-profit court. They're making you be the trustee, right? Well, no, you're the heir and the executor, and you want to appoint them as trustees of the estate. Then they're in the bitch position, right? Which again is all done by the doc set. All right, to continue. The IRS and the state tax boards are the trustees of your estate because of your silence. Well, actually, they're special administrators. That's not exactly how I'd say that. I would say the IRS and state boards and the entire Bar Association are being special administrators of your estate, right? And again, because of your silence. If you want to get back to the Republican form of law, you have to use the state probate court to sever the trust relationship. Once the trust is broken by the courts noticing your will in expatriation, you can take back your estate. The trustors receive your trust in operation of law. You can take it back by exercise of your private use of public municipal law. Also remember that the individual is presumed to know the law. Ignorance of the law is not an excuse, right? And all this is an aspect of what's called, in England, it used to be called suing out your livery. That particular term of art isn't used in American jurisprudence, but what Edward Mandell House refers to it as is redemption, that they will be forever without redemption is what he says in his quote when he's talking to Woodrow Wilson about what they're going to do. Well, the redemption of the estate is the point. So you get your VSOF status doc set done, and then we can start probing the state probate courts as far as opening up a probate case in solemn form. That's the particular kind of probate that we need to do, because probate in solemn form specifically goes through every single piece of evidence and puts everything onto the record to make sure that no one, meaning no attorney, can interplead between you and your estate, because that's what they're all doing. And if you go look up the term interplead, it means getting in between an heir and his estate before he can claim it. That's interpleading. And that's what every single attorney is doing out here. It's all interpleading, all of it, because they're constantly keeping you away from the lawful title and to having to hold forever your estate, which includes, by the way, your body. Another very important reason for the courts having to sever the trust relationship is to protect the trust. Right, because you don't want anything to do with that trust. It's their thing. I don't want to, you're over there. Here's the line in the sand. Here's the fence, right? Your grass is over there. Mine's over here. Don't touch. If there was no judicial noticed action, there would be nothing to stop the individual from bringing suit against the trust to receive benefits from it, even though they had never paid a dime in the form of taxes. Right. So they're doing their thing. That's fine. Set up your trust, whatever. But I'm not part of it. I'm over here. And by the way, you can't have any res of my estate to put in any constructive trust, whether it be the 14th Amendment or the bloody court case that you create, because every little court case is its own little constructive trust, by the way, which is why they're all bonded. And also why the attorneys all take money off of them through the IOLTA trusts, which stands for interest on lawyers' trust accounts, by the way. Another interesting thing that you can go look up. And where the judges take all their retirement funds from is they go and set up 501c3 religious non-for-profit, right, organizations, and that's their retirements. Because why? Because the judges are all sitting up there as priests of hell. This is all being run through ecclesiastical jurisdiction, everyone. So understand all that. And if you have to go back and re-listen to what I just said 5 times, do it. And then go look everything up that I just said. Because I'll back up everything that I say, but I'm just not going to go look up every single word right now. Okay, because we're coming up on about an hour. All right, to continue, or to finish up here. The Founding Fathers established a republican form of government right in the beginning. And what is unique about the United States being a republic is that we had a constitution to spell everything out about its operation and relationship to its citizens. Notice that, capital C, citizens, not lowercase c. The Constitution of the United States of America was designed to protect the minority from the majority. All other republics fail mainly because they do not have an instrument that defines what the republic is and how it should operate. And I would add to that a very important point. All other republics do not have their people as sovereigns. They're not sovereign. It might be a republic and there might be citizens of them. Great. But we, the people, are sovereign above government. We need to start acting like it. We need to start taking action in the form of forming grand juries in 25-member grand juries of the peerage after we get out of this mess by saying, no, thank you. I'm in the proper common law and I'm over here and you're over there. So when you trespass upon any of us again, meaning any of us that are out, we instantaneously form a 25-member grand jury of the rest of us that are out and say, hey, what are you doing? You're going to come after one of us? No. We already told you we're out. Now we're going to form a grand jury and crush you and take everything from you. That's the power that you have when you have proper standing. Okay. So I'm going to stop here for the reading, and I'm just going to scroll down in chats here and here if there's any questions that anybody had one way or the other. And if you have any questions, you can go ahead and ask them now, or you can put them in the chat. So, okay, TJ said, I wonder if the age majority also refers to, of the majority also refers to age majority and not just the majority of its members. Yes, in a sense it does. And always remember also about that term age of majority. That's what the attorney uses to stick you under the democracy because of the presumption of when you hit 21, which I didn't bring up tonight, but just for argument's sake, under the U.S. Code, it says that the presumption kicks in after 21 years of age that you are a citizen of the United States, unless priorly rebutted that you were not born in the United States, meaning in the District of Columbia or some other federal territory owned thereof, and then subject to the jurisdiction of Congress, right? Well, they use the term age of majority to stick you in there, where the proper common law term that we want to be using is always having come of full age, which is how it's written in the Magna Carta, and also how it's written in some statutes as well that I've seen, particularly in Illinois and a few others. But I won't go searching for them. I'm just telling you, they're out there. So you always want to look for the term come of full age. Yeah, Viper, the 7 liberal arts. I'll just repeat them again. But the 7 liberal arts are grammar, logic, and rhetoric, which is what's referred to as the trivium. And then the quadrivium, or the next 4, are mathematics, geometry, which is mathematics and space, music, which is mathematics and time, and then astronomy, which is mathematics and space and time. And if you study all 7 liberal arts, then you are considered to have a liberal education. But no one gets a liberal education anymore. And CLF3 put them in the chat anyway. All right, cool. So, and there's classes on the trivium as well. If anybody wishes to study the trivium, you can do so by going to the Vocational Science Freedom Odyssey page, clicking on playlists, and going to the critical thinking method. The critical thinking method is where I covered, I think in 3 classes, we went over the trivium extensively, which I also used some teaching material from Richard Grove at tragedyandhope.com. So I thank Richard for that information. And you can study the trivium in its entirety in those classes. So, TJ, federal common law of admiralty. Well, that's kind of an oxymoron. There's federal admiralty, and then there's the aspect of common law. So the two of them shall never meet. But anything else?
That's why I put it in quotes. That's why I put it in quotes.
Yeah. Is there anything else? And you're just showing the aspect of the Indonesian money. Yep. Back and forth. Yep. Signed twice. Exactly. Every single note. It doesn't matter what country it is. It's irrelevant. Every single country that has a central bank, you look at their notes and they'll all have 2 signatures. Doesn't matter. And thanks for putting that up, Obed. I've never made that point before. I mean, I always knew it in the back of my head, but I never had a picture of it. So that's cool. Thank you. And I'll just click on it just real quick to make sure that everybody else can see it, because that was probably too small to show. But here's the two signatures right there. So this dude owes this dude whatever this debt note is of whatever central bank that's a part of, whatever it may be. So, no, from a standpoint, because if you're considered an outlaw to the law, okay, let me explain this. If you're considered an outlaw, and the question was, by the way, what Viper said, if we are considered quote unquote outlaw, what keeps them from arresting us, said outlaws? And the answer is nothing. Because an outlaw, if you're labeled an outlaw within the jurisdiction of wherever you may be wandering, it doesn't really matter. It could be France, England, here, or in this fairyland of the federal jurisdiction, right? If you are by presumption under the jurisdiction of whatever the jurisdiction is, and that jurisdiction calls you an outlaw, what that means is that you no longer have the protection of whatever law that they're operating under. So they can pretty much do whatever they damn well want to you, which is the problem. And they do, right? Clearly. So, yeah. And there's whole treatises on the aspects of outlawry. Well, what they used to do sometimes for outlaws is they would expel them out of the country. They'd chuck them, say, get out of here, right? Which is what we should be doing right now with probably most of Congress. But anyway, okay. Does anybody have any questions that they want to bring up or ask? And if not, with the idea that the republic is designed to protect the minority from the majority, has there always been a republic for sovereigns and democracy for plebes? Well, no, not really, because in a sense, well, I don't know. Can I think about that for a second? Okay, so colonies were controlled by Admiralty and the king. Then King George canceled all the charters, so that wiped those out. We were all sovereign. We created the states. We created the Articles of Confederation. No, so during that time, there wouldn't have been any democracy for the plebes at that time. Unless, well, no, it still wouldn't have been a democracy. They could have said that, yes, I'm still a subject of the king, so they had that choice. But that wouldn't have stuck them under a democracy during that period of time, from the Revolutionary War to all the way to the 14th Amendment. So from that period of time, from there to the 14th Amendment, there wasn't anything that you would have considered a democracy, no. But once the 14th Amendment came into existence, well, I guess basically when the Union split up, yeah, no, because the northern states would still have been republics at that time too. Yeah, it really wasn't until the 14th Amendment that it came in. So, well, if you weren't someone, okay, so the question was, what were the non-landed, non-electors considered? You could have still been considered a citizen of the state of which you were born, but you wouldn't have been considered to be an elector without land. But it's kind of a funny thing back then, because there was so much land that people could get land grants. You could buy it for very, very inexpensively. And not to mention that also that there was a lot of lands given by what was called scoage or shield payment, which was lands that were granted out by either serving in the United States military during various different wars, 1812, Revolutionary, whatever, and also Civil War too, that then had allodial titles, which were the land patents that were given afterwards. But free inhabitant doesn't equate to pauper. A free inhabitant would be anyone that is a free inhabitant, which wouldn't necessarily have to be someone that owned land. So yeah, I guess that is basically the answer sounder is what TJ said. You would be considered a free inhabitant, but then you wouldn't necessarily have to have been a landed owner or an elector, but a free inhabitant still would suffice. Because if you read the Northwest Ordinance, I think the word free inhabitant pops up, 3 times. So that was kind of what they were calling everybody in the territories who, maybe had been there for a while and they had already had a homestead, but it wasn't considered a state yet, or it hadn't even been purchased by the United States of America yet with the, from Jefferson's purchase from Napoleon, meaning the Louisiana Purchase, right? So they were referred to as free inhabitants. And a pauper is anyone who's basically a bankrupt. Now, paupers, that gets into settlement certificates, which were kind of like the precursor to birth certificates, but I don't want to go down that trail because that's like a whole nother class right now. So the question is, are all debts prepaid by HJR 192? The answer is no, they're not, because there was another passing of a Senate document, and I forget the name of it. I probably have to ask TJ again about it. There was another passage of something that they altered HJR 192 where it doesn't allow them to have to pay for it. Yeah, is that it? Public Law 7310? I think that might be it. They altered it so that, no, it doesn't work the way that everybody was trying to make it work, like, say, in the late 80s and early 90s, like trying to make them pay the debts. Well, they shuffled along and they said, nope, that's not what we're doing here. So, okay. So with that, I think we're 15 minutes over. I will end it for the night. And I would like to thank everyone for coming and participating and listening. And if you'd like to, again, join the Vocational Science Freedom Gilded server, it's gilded.gg/VSOF, and make sure to like and follow on all of the other platforms that the Vocational Science Freedom is on, which are Odyssey and on Rumble. And our Gab group is Gab group 30721. And I restarted the VSOF YouTube page, which is Save the Republic at VSOF, and I'll get the rest of the videos put back up that aren't offensive to communists. And with that, so I'd like to thank everybody for coming and enjoy the rest of your week. And I will see you guys again on Wednesday night for the Open Roundtable. And until then, as always, stay safe and stay sovereign.